Okay, so Laurie, thank you for bearing with us and for the slight delay in the program. Laurie will be joining us virtually. And just to introduce you, we have Lauren Handel, Principal Attorney, Handel Food Law, LLC, United States. Welcome to this session.
Thank you. Thanks for having me. So, hello, everyone. My name is Lauren Handel. I have a very small law firm in the United States called Handel Food Law. It's myself and two other attorneys. And as you can tell from the name of my firm, we are focused entirely on the food industry. So all of my clients are in some part of the food industry, from farming, wholesale, distributors, importers, retailers, manufacturers, some restaurants and caterers. And a lot of what I do is regulatory compliance. So I advise companies on US food regulations and state regulations with regard to the manufacture and labeling and advertising of food products. I also do a lot of trademark work. I caught the end of the presentation on trademarks, which is a big part of my practice. And then I also do a lot of work with commercial contracts that are common in the food industry. Okay, so the topics that I plan to cover today, and I titled this Legal Expectations of US Food Buyers to try to give you a sense of what will be in the mind of an importer here in the United States who's considering buying your products. And a lot of that will be driven by the legal framework here and the potential liability concerns. So I think it will be helpful to understand if you're thinking about exporting food products into the United States. So to start, I'm going to talk about what's called the Pure Food Guarantee, a very common contractual provision that is really demanded by distributors and retailers in the United States. A very brief overview of the regulatory framework for food in the United States. And then we'll talk about a relatively new regulatory program called the Foreign Supplier Verification Program under the Food and Drug Administration. Food labeling litigation risks, which are maybe the biggest source of potential liability right now in the United States. And then another new program that goes into effect next year for labeling of bioengineered or genetically modified foods. Okay, next slide, please. Okay, so the Pure Food Continuing Guarantee. This started with the Pure Food and Drug Act, so that's why it's sometimes still referred to as a Pure Food Guarantee. But if you're doing business or starting discussions with a buyer in the United States, you are very likely to be given a form or to have requested of you a continuing guarantee and indemnity. And so this is a language that distributors and retailers will ask you to sign, guaranteeing, ensuring that all food or beverage goods, as of the time they are delivered, are not adulterated or misbranded and comply with all applicable US and federal and state laws and regulations. And this is a continuing guarantee so that from the time you sign it, every delivery and shipment of goods thereafter fall under this guarantee, and you are making this promise. These forms also very typically require an indemnity. So you are agreeing to indemnify, defend, and hold harmless the buyer for any breach of that guarantee and any other costs or damages or claims that they may face as a result of buying and selling your products. Next slide, please.
Next slide.
So why do they do this? So I mentioned it started with the Pure Food and Drug Act, which provided that there is a defense to criminal liability if a buyer, someone who's selling a food product but wasn't involved in the manufacture of it, if they get a guarantee like this, then that provides them with immunity from criminal prosecution if there is a violation in the product. Now, I'll tell you that criminal prosecution and enforcement of the food laws in the United States is very rare. And yet this kind of guarantee is almost always demanded. And that's because there's other potential liability. And the language of these guarantees has really expanded to cover basically every type of liability that a seller could face for selling a food product. In the US, every entity in the chain of commerce, so from the manufacturer, wholesale, distributor, retailer, is potentially liable for a defect in that product. So we have a doctrine of strict product liability in every state. If you are a seller of a product, and this isn't just for foods, but any kind of consumer product, and there is a defect in that product and it causes harm or injury to a consumer, then any party in that chain of commerce can be held strictly liable, meaning they are liable for the damages, even if they were not at fault, even if they did not do anything wrong or participate in the manufacture. So there's that at least theoretical liability, and buyers will want to push that back onto the upstream manufacturer contractually. And so these provisions allow them to do that and give them a right to recover, so that in the event that, let's say, a US retailer is held responsible for a product defect or something wrong with its labeling, well, then they have a right under the contract to sue the manufacturer, not only under common law theories, but also for the breach of contract. And so they've become very standard and very broad, much broader than was originally contemplated in the Pure Food and Drug Act. Implications for you as a company that is exporting to the United States. Obviously, you'll need to ensure compliance with federal, US, and state law, and maintain adequate insurance coverage. So those are things you would probably want to do anyway. But just recognize that your buyers will put sort of an extra emphasis and importance on compliance and insurance. And actually, almost all US retailers have minimum limits, coverage limits for insurance that they're going to require that you show proof of coverage and that you've named them as additionally insured. Okay, the next slide, please. So overview of regulation of food in the United States. At the federal level, so first understand we have multiple layers of regulation, federal and state. At the federal level, it depends largely on what type of products we're talking about. So the Food and Drug Administration has responsibility for all food generally, but for certain types of products, the primary jurisdiction has been delegated to the US Department of Agriculture. And so specifically for meat, poultry, catfish and related species, fish products, and egg products out of the shell. It's kind of weird quirks in the law that have resulted in these different jurisdictions between those two agencies. US Department of Agriculture also has responsibility for organic food labeling and production regulations, and for what I mentioned earlier, this new bioengineered food disclosure. The Federal Trade Commission is responsible for advertising at the federal level and consumer protection laws. And then the states also have jurisdiction and responsibility for food safety and inspection and their own requirements that, for the most part, they're enforcing federal law or have adopted federal law in their own state codes. But states are also allowed to have extra requirements with regard to labeling. And I'll talk about one very significant aspect of that in California with Proposition 65. States also have their own consumer protection laws that mirror the Federal Trade Commission law. And then I've listed here litigation plaintiffs and their lawyers. So you may not think of this as regulation, right? I'm not talking about an administrative agency, but the reality is that a lot of the food laws end up getting enforced in the courts in the United States, in particular with regard to advertising and labeling of food products, because there's a lot of lawsuits that get brought around those things. But then also, obviously, if there are personal injury claims, those very frequently get litigated in the courts as well. Next slide, please. Okay, so turning to the Foreign Supplier Verification Program, I mentioned this is relatively new. So there was a statute called the Food Safety Modernization Act in 2011, and it took years for the regulations to be promulgated and to actually go into effect. And really just last year, FDA stopped doing most, because of COVID, stopped doing most on-site inspections that were just routine inspections, but ended up doing a lot of foreign supplier verification program inspections remotely because they're just records reviews. So if you look on FDA warning letters, the most recent ones, a lot of them are for violations of this foreign supplier verification program. And this program basically puts the obligation on importers in the United States to verify that the companies they are buying from overseas are compliant with US law. And so, whereas it used to be that this would probably still happen to some degree because, as I mentioned, all of the liability that downstream sellers would face, it is a very good business practice to verify that your suppliers are complying with the law. Well, now affirmatively, importers have that obligation and can be held liable for violating regulations if they fail to do this supplier verification. So before importing, a US importer is supposed to be verifying that the foreign supplier is compliant with all FDA regulations that apply, including hazard analysis and risk-based preventive controls, which is another relatively new program under the Food Safety Modernization Act. Current good manufacturing practices, which recently were expanded to include more strict requirements for allergen control. Produce safety rule also under the Food Safety Modernization Act, and so that applies to whole unprocessed fruits and vegetables that are typically consumed raw. So that would apply if you were an importer of fresh produce. Low acid canned food regulations, and so those are the rules for shelf stable canned products. And this program applies if the importer is relying on the foreign supplier to control the hazards of the product. So if the importer is a manufacturer that is importing an ingredient that they intend to use in a product that's going to include a kill step, that's going to take care of any hazards in that ingredient, then this program doesn't apply. But if in all of their circumstances where there's a potential hazard and the importer is relying on the foreign supplier to control that hazard, then the requirements apply. Next slide, please.
Can I ask a question?
Sure.
Sorry, can I ask a question?
Yes.
Sorry. Because we have, I'm not sure we understand properly what this means when we talk about foreign supplier verification, because we have like processed food that does not contain meat that can be exported to the US, provided the companies register with the US Food and Drug Administration. But do they, if I'm exporting processed food, do I still need to have a foreign supplier verification? This is one issue. The second issue is if I'm exporting dairy products, where do I register? What do I do? And then the meat, we know the meat is not allowed because Jordan is not recognized as equivalent. So how can I say this? These challenges to know what the product is because as AmCham, as a technical unit, we're getting a lot of questions, and we're finding difficulty navigating the US system. So I don't know if you can give us an example per food product, because let's say if I'm doing chocolates, can I export them and I register and I want to go sell them to the US? Or is a foreign supplier verification attached to the level of risk of the product? I know my question isn't clear because I'm not super clear on some of
No, I get it.
Yeah, okay, thank you.
Yeah, so So I'm going to get to the implications for you. So the purpose of discussing this is for you to understand on the US side, the party that will be importing these products from you, what are the legal obligations on them? As the company in Jordan that's making chocolate, your obligation is to, yes, register with FDA and comply with all FDA applicable requirements for that product. So the hazard analysis and control program, preventive controls program, that applies to all kinds of products. All of the labeling regulations. So the requirement to comply with the substantive regulations is on the manufacturer. The importer in the United States has to verify that the company overseas that's producing the product or that's supplying the product is compliant with all of those rules. It basically puts the importer in the shoes of the regulator to make sure that their suppliers from overseas are complying with all of those rules. Does that clarify it?
Yes, so there's the obligations remain the same, but it's an added burden on the importer.
That's right.
And you will tell us how they will verify. What do they
At a
do
very high level, yes. So,
and what is the role of the US FDA in this? Because they come and inspect as well, you know?
That's right. That's right.
Just to
So
see,
FDA
like,
will inspect. The purpose of this program, I think what the reason why it exists is the recognition that FDA does not have the resources to adequately inspect everyone, especially in other countries, even though FDA has a presence all over the world. So that is why there's this additional obligation on the importers to be verifying. And now FDA is also inspecting the importers to make sure that they're verifying that their foreign suppliers are complying. So there's multiple levels of protection or enforcement, if you will, in that at any time FDA could come in and also do an inspection at the facility in Jordan and make its own assessment of whether or not that facility is compliant or the products are compliant. And that is a separate issue from whether the importer complied with its obligations under the Foreign Supplier Verification Program. This is driven by hazard analysis. So either the importer has to itself conduct a hazard analysis of the products and the operation and decide what level of verification activities will be required, or the importer is allowed to rely on the supplier's own hazard analysis, but it does have to review that and make a determination that it was a reasonable hazard analysis. The importer also has to review the supplier's performance and then conduct verification activities. There is a presumption that if a product is potentially hazardous in the sense that it carries the risk of serious illness or death, then annual on-site audits are a required verification activity, and the importer would have to show FDA that other kinds of verification activities are sufficient. Otherwise, it's presumed that the only way to ensure that the supplier is controlling that hazard is through annual on-site audits. And all of these things have to be done by qualified individuals. That's the language that's used. So people who actually know something about food safety and are adequately trained. Records review can be another form of verification activity. So for relatively not hazardous products, it may be sufficient to just do records review and not any on-site audits. And product testing can be another form of verification. Next slide, please. So the implications, what does this mean for you? And so, the reason why I want you to be aware of this is, first of all, as I mentioned, there's been a lot of activity in enforcement of these rules. Now, over the last year and a half or so, it's really started to ramp up enforcement. And so US importers this is going to be on their mind. And a lot of US importers are frankly behind and really need to catch up on their compliance with this program. So as you start talking to companies in the US about potentially importing your products, just expect to be asked a lot of questions and that you will need to demonstrate your compliance to those buyers. So expect detailed inquiries. And again, to some extent, this was always kind of good practice in the industry for buyers to be looking into your operations and food safety, but now it's going to be even more so because of this program. So expect to get a lot of inquiries, expect to have a lot of records requested and requests for access and third-party audits. But be aware that third-party certification, so like Global Food Safety Initiative, SQF certification, while it will certainly help, it is not necessarily sufficient to satisfy this regulation. And FDA is actually doing a pilot program now to evaluate to what extent the common third-party food safety certifications will satisfy this regulation. So be aware that you're going to be asked to supply a lot of documentation, a lot of which will contain very proprietary information. And so you will really want to make sure that you have strong confidentiality protections contractually in place with anyone who's requesting this type of information. Next slide, please. Okay, so I'm going to turn to labeling and advertising. As I mentioned earlier, it's probably right now the biggest source of, or I'll say most common source of liability, not necessarily the biggest dollar amount source. Certainly you could face more liability in terms of the financial impact if there was a product defect and personal injury kinds of claims. But there is very active litigation in the area of labeling of food products. And so just as an overview first, there's a regulatory obligation to not misbrand food. So food that is being sold in US commerce or even held for sale in US commerce is illegal if it is misbranded. And misbranding takes a few different forms. So kind of the most obvious version of misbranding is that the labeling is false or misleading in any significant way. And that can be because it's inaccurate or it's deceptive in terms of claims that it makes that are not entirely true or that can be misleading to consumers. But it also can be because there are material facts that a consumer would need to know to make an informed decision about whether to purchase the product, and the label fails to disclose those facts. A product can be misbranded if it's misleading as to the fill of the container. So if the consumer will look at the size of the package and think that there's a lot more of the product in the package than there actually is, even if it's accurately labeled as to its net weight or volume, that can be a form of misbranding. And then violation of, there's a whole host of labeling regulations about all kinds of things, mandatory label information. So things like the statement of identity, the net weight, the ingredients list, the allergen declaration, the nutrition labeling. So the failure to comply with any of those rules is misbranding. The failure to comply with regulations about the regulation. Oh, sorry, I just got a warning notice on my computer. Failure to comply with regulations around certain kinds of claims, which I'll talk about a little bit more, is a form of misbranding. Standards of identity, so those are rules that define kind of the composition of certain kinds of foods. We don't have a lot of those in the United States, but there are some for sort of more traditional staple grocery items. There are very nitpicky rules about how you describe the flavor of a food product. And so those are examples of labeling rules that the violation of any of which is considered misbranding and makes the product illegal to sell. Next slide, please.
I ask a question here.
Sure.
Because like the labeling is in Jordan, for example, you find the labeling in text, in legal instruments. I don't know where the labeling requirements are, for example, for food safety. Where do I find this? Is it in the consumer protection legislation? Where do I find the labeling, the minimum labeling labeling requirements? If I want, because we get a lot of questions, what should the label be? And I don't have, I don't know where to look. Where do we find this stuff in the US?
Sure. So, unfortunately, the best resource that we have is out of date. It's still a good place to start. So, FDA has its food labeling guide, which you can find if you Google FDA food labeling guide. It's a PDF document. It's from 2013. So there are parts of it that are not entirely the law anymore, in particular with regard to nutrition labeling, because the nutrition labeling regulations were updated significantly in 2016. But overall, most of it is still good law, and it is a good place to start to understand the mandatory labeling elements and what kinds of claims are regulated, and just kind of generally the rules. You always have to check the regulation themselves to see, because the guidance is just guidance. It doesn't have the force of law. So the actual regulations are in the US Code of Federal Regulations. 21 CFR Part 101 is all of the labeling regulations for FDA foods.
Okay, so the actual code, but they're not in standards, because in Jordan, you know, like the metrology and standard and metrology. Yes. No, we have an organization in Jordan just for this. So sometimes the labeling, the exact labeling requirements are there as a standard, and there are some other things that are regulated at the Food and Drug Administration under specific items, like food is one of them, and another one is for like different products like cosmetics, chemicals. So you will find there's a general standard, and then there's the substantive standard as in the regulatory authority. So in the US, it's in the federal code.
Yes.
What's the federal code for?
So the Code of Federal Regulations is all of the regulations of the federal government broken down in different titles by agency. So 21 is Food and Drug Administration, so 21 CFR, and then there are different parts within that. Part 101 is the part for food labeling regulation.
And let's say if food, but also agriculture, meat stuff, or that's the agriculture, I would have to go to chapter, 27. 27?
Yeah, so you had 7. USDA regulations are in 7 parts, Title 7 and 9.
Part 7.
It is a confusing system. It makes it difficult because there's not one place you can go to find everything. And that's why I said the food labeling guide is an effort to make it more user-friendly, but it badly needs to be updated.
No, I agree with the same in Jordan, but maybe it's a bit easier to find in Jordan because it's by, there's a code just for agri. It's not under a general code. So that like a code of federal. And then, so the federal is the general rule, and then you have state rules, right? For labeling?
You do, but
those?
so for the most part, so we have a doctrine of federal preemption, which is under our Constitution. State law is not allowed to conflict with federal law. So for the most part, the state laws regarding labeling are the same as the federal law, or in many cases, they just incorporate federal law by reference. That said, states are allowed to have some extra requirements. So as long as it doesn't conflict with federal law, a state can have some additional requirements. There aren't a lot of those. The most significant one is California's Proposition 65, which I'm going to talk about.
Okay, but I have one last question. Sorry, I know I'm bombarding you, but I've been waiting for this for months. So in the European Union, there's something called, because of the single market, any product that's allowed on a single country can freely circulate into the other one. So let's say I export to my product, the label, everything based on New York law. Is there the same principle that what's allowed on the shelves in New York should automatically be allowed into California, even with this proposition thing, or there is the state of California can stop the circulation because it doesn't meet its requirement. This is a principal question.
Yeah.
Yeah.
Generally, yes, as long as a product is compliant. Again, it's because it's mostly federal regulation. A product that complies with federal law is lawful everywhere. California is kind of its unique little island. The Prop 65, though, doesn't get enforced in that way. It doesn't, a product that violates Prop 65 doesn't get pulled off of shelves, but the manufacturer or the seller gets sued for damages instead. So it's lawful to sell products that are compliant with US law anywhere. And there are some quirks here and there to state law that depend on the type of product. But the presumption is that states cannot interfere with interstate commerce. So it would be very difficult for a state to block the sale of a product that was lawful to sell in another state.
Thank you.
Okay. Can we go to the next slide, please?
Does Handel law handle animal feed or just food for human consumption?
Also, animal feed and food, yes.
Okay, thank you.
Sure.
And back to Lamb's question. Basically, most Jordanian food manufacturers work under private label. So it's a joint responsibility between the buyer and the seller when they are exchanging, samples and labeling requirements to be able to meet with the requirements, labeling requirements that will be placed on the shelves in different states, right?
Yeah. So a private label arrangement, so obviously it's up to the parties how they want to allocate responsibility. Most private label agreements that I've seen put the responsibility for labeling on the brand owner. Since the product's going to be sold under their brand, they create the label, or at least provide the content that goes on the label and take that responsibility. Now, of course, then the manufacturer has to produce the product to the specifications. Otherwise, there could be labeling problems, right? The ingredient list can be wrong if the manufacturer didn't produce the product correctly. That's typically the way that I see it in a private label situation. As far as the regulators are concerned, the manufacturer still is going to be responsible for compliance with all of the rules, right? So if FDA comes in and is inspecting a manufacturing plant, it doesn't really care about your private label agreement. It's going to want to make sure that you're producing products that comply with all the applicable regulations, including with regard to their labeling. Does that answer the question? Okay. So quickly on types of claims, this is just to give you an idea of sort of the territory where you should have red flags up and look more closely at the rules, because there are very particular rules about these kinds of claims that get made on the labeling of a product. So any sort of claim about the nutrient content of a product, so even just saying that it contains fiber, or it's a good source of protein, or it's low in fat, all of those things are regulated by FDA, and there are particular rules about what language you can use and when you can make those claims, and in some cases, additional disclosures are required. Even the word healthy. So if you describe a product as healthy, or with any variation of that term, healthful, healthier, healthiest, with regard to its nutrition or its ingredients, that's also regulated, and there are particular criteria for when that kind of claim can be made. Gluten-free is defined in FDA regulation as less than 20 parts per million and no gluten-containing ingredients. Disease claims, meaning a claim that a product is useful in preventing or treating or mitigating any sort of not normal health condition, is absolutely prohibited for foods or dietary supplements. Then there's a category called health claims, which are really not attractive from a marketing standpoint because FDA allows them only if you use very particular language that wasn't written by marketers. So as an example here, while many factors affect heart disease, diets low in saturated fat and cholesterol may reduce the risk of this disease. You can find, actually in the food labeling guide, you can find all of the approved health claims that can be made and when they can be made. Structure function claims are another kind of health related claim that doesn't require you to get FDA's permission to use it, but you do have to have adequate scientific substantiation. So this is a claim that a product or something in the product has an effect on a structure or function of the body. So an example of that is calcium builds strong bones, or that a product is useful to support the immune system. Those are kinds of claims that are allowed, again, if you have adequate substantiation, and they do not need to be pre-approved by FDA. And then anything around organic, those are not FDA regulations, those are USDA regulations, but even using the word organic anywhere outside of an ingredient list is requires certification and that you meet the criteria of the National Organic Program standards. The next slide, please.
So Laurie, bottom line is that you have to be able to defend any claims you put on your label.
You do. So all claims require substantiation, but even if it's truthful, so this is kind of the point that I think intuitively doesn't make a lot of sense, but even if you say something that is truthful and that you can substantiate with evidence, doesn't necessarily mean you can make the claim or make it in the way that you want to make it. Because if there is a regulation that may say, okay, well, you can only use these particular words, or there are particular criteria that even if you think the claim is truthful, FDA still has made the determination that it's potentially misleading unless the criteria in the regulation are satisfied.
So if, like, I'm exporting chickpea powder and I claim it to be gluten-free, halal, and kosher, where do I stand without the certifications of halal, kosher, or gluten-free?
Okay, well, so kosher always has to be certified. Gluten-free is not required to be certified. If it's chickpea powder, as long as it has less than 20 parts per million of gluten from unintentional cross contact, then that claim is allowed.
Okay, thank you.
So litigation risk. So just understand that America is litigious, that there is an industry of class action plaintiffs lawyers who have seized on food labeling as a really ripe area for bringing lawsuits, and it's really easy for them to do so. So in our system, it is very easy to bring a lawsuit and to allege enough to get the case past the motion to dismiss, which would be the defendant's first opportunity to try to get a case knocked out. The standard for surviving that motion to dismiss is pretty low in all states. So it makes it very easy for plaintiffs' lawyers to bring claims or to even threaten claims, and to really create incentives for defendants to settle. And this is what you need to understand is very few cases in general, but also in particular for food labeling, ever get to trial. They almost always settle. Many of these cases settle even before they're filed. The plaintiff's lawyers very typically send demand letters before they even file a complaint. And a lot of cases settle at that stage. And the plaintiff's lawyers know this, and their aim is really not to bring cases that they think they can win, because they don't expect to ever have to get that far. And so there are a lot of food labeling cases that get threatened or brought that are really pretty weak cases and still would put on the defendants the burden of having to defend them, to pay for the defense costs, and very likely to pay for settlements. So it's something that's really important to watch out for, and that makes it even more important to ensure compliance with food labeling regulations. Can I have the next slide, please? So some targets, I'll go over this real quickly in the interest of time, but some of the targets of the kinds of labeling issues that have gotten a lot of people sued in the last 10 years. Natural was the biggest one and still continues to be active. So foods labeled as all natural, 100% natural, or they use natural, and now there's different versions of that. Clean, real, pure, all of that kind of labeling for particular kinds of products, if it's even arguably not natural, get people sued. No artificial flavors or preservatives. So category that's called health washing. I'll give you an example of that. Then violations of the very nitpicky regulations about how characterizing flavors are described, or representations about key ingredients in a product being potentially misleading, claims about sustainability and animal welfare, and then Proposition 65, which I mentioned before. So the idea here is that plaintiffs' lawyers will sue on behalf of a class of consumers, typically all of the purchasers of a product nationwide or within a particular state or group of states who bought the product within the last usually 4 to 5 years, they will say are harmed because they were deceived by the labeling of this product. I'm getting a warning that we have 5 minutes left. Is this going to cut off in 5 minutes?
No, keep going.
Okay. All right. So next slide, please. Okay. So here's an example of a lawsuit targeting, as you can see, the Wesson oil was labeled pure and 100% natural. It's canola oil. In the US, most canola is genetically modified, as was this product. And so the allegation was it's not pure and 100% natural because genetic engineering was used to create this product. Other kinds of products are anything that is highly processed, contains any kind of synthetic ingredients or artificial ingredients. Some of these cases have been brought because the plaintiff's lawyers have tested the product. So for example, oatmeal was tested and found to contain pesticide residues at really, really low levels. But still, because the product was promoted as natural, that was alleged to be deceptive, and that consumers wouldn't expect there to be pesticide residues. Antibiotic residues in dairy products is another example of that. Next slide, please. No artificial flavors or preservatives. So this is different than saying natural. There have been a lot of cases recently where products that contain multifunction ingredients, so citric acid, malic acid, other kinds of ingredients that have more than one function and aren't really there as a flavor, but maybe enhancing flavor. They're typically used as acidity regulators, or again, maybe as a flavor enhancer, but not what you would normally think of as a flavor. And so this is an example of a product that is the subject of a lawsuit. No artificial sweeteners, flavors, or preservatives is the claim. And yet it had citric acid, I think, was the ingredient in this beverage mix. And there have been a lot of these, largely driven by one or two plaintiffs' law firms who file dozens and dozens of these cases. And something you need to understand is, even if your label is 100% compliant with FDA regulations, while that will certainly help, it does not necessarily immunize you from this kind of litigation, because it is possible, and the courts have recognized, that even if a label is compliant with FDA rules, it still could be considered deceptive to consumers under state law. Next slide, please.
But one question:
Yes.
if I'm an importer and I've verified that my exporter, but I didn't look at the label, then the liability falls with whom? Still, my first call of liability will be the importer. the level of responsibility is on the product and the packaging and the label, or just the product itself?
So potentially anyone involved gets sued. Practically, what's likely to happen is whoever's name is on the product, right? So on the back or the side of the product, there's it's called the signature line, which identifies the name and address of the manufacturer or distributor of the product. They're going to be the most obvious target for the plaintiff's lawyers to sue, but they will do their research. And actually, even after the case is already filed, if they discover that there were other parties who were responsible for the product's labeling or the distribution of the product, they also could be sued.
Okay. Okay, so but the law, the verification law, doesn't talk about because the whole point of the verification law is to place the importer in liability with in responsibility and liable for the product, right?
Yes, but only with regard to food safety, and it's completely different law than the law under which these lawsuits are brought. So these lawsuits are not being brought to directly enforce FDA food labeling regulations. They often refer to FDA food regulations as evidence of what is false or misleading to consumers, but there's no right. Consumers do not have the right to bring a case to enforce FDA's regulations themselves. There are separate state laws that prohibit unfair or deceptive or fraudulent marketing practices, including labeling, and those are the laws under which these lawsuits are brought.
Okay, that's so. I just wanted to be sure. No, I understand. Thank you.
But okay. There's also clauses about pre-approvals and conformity, right?
I'm not sure what you're asking. So FDA doesn't approve any labels.
We're talking about for shipping purposes, for importation purposes.
FDA does not approve any labels. So USDA is different. USDA requires pre-approval, and it's actually a lot more difficult to bring a lawsuit like this for a meat or poultry product for that reason, because of federal preemption. But FDA does not pre-approve labels. It's not required, and they won't do it. So it's up to everyone who sells a FDA regulated product to confirm for themselves that the product is compliant. But again, remember, compliance will only be, it will be a useful defense, but it will not guarantee your success in a lawsuit like this, because a product can be 100% compliant with FDA labeling regulations and still considered misleading or fraudulent to consumers.
Thank you.
Okay. Another, I mentioned health washing. So this is an interesting, relatively new kind of theory for these cases, where even there's not one particular claim that they're targeting, but rather the overall impression that the product's labeling or marketing conveys. So in this case, this cereal, it's got claims about omega-3 content, 8 grams of protein made with real fruit. There were other things in the advertising where it's trying to convey the product as a healthy, nutritious breakfast option. And the allegation is this is misleading to consumers because it has very high sugar content. And there have been a number of cases like this for a variety of products. And it's, and again, we don't know how they would fare if they ever got to trial, because they end up settling before they get to trial. Next slide, please. Okay, Prop 65. So that's the shorthand for Proposition 65, which is actually a Safe Drinking Water Act in California, and really has to do with way, way more than drinking water. So this is a law in California that products, or really anything that exposes consumers to chemicals on a list that you can find on California's website, that the state has determined are carcinogens or reproductive hazards, require a warning unless a safe harbor applies. So For certain chemicals, a lot of the chemicals on the list, there is a safe harbor level. And if your product has the chemical below that level, then a warning is not required. And again, it's not illegal to sell products that don't have the warning per se. They're not going to be stopped from sale, but you can be sued for damages, and there is what's called a bounty hunter provision in this law, which gives plaintiffs' lawyers the ability to bring a class action on behalf of all consumers in California against whoever's responsible for not giving the warning, for injunctive relief and for damages. And it's a significant issue. So if you plan on selling products that will go to California, this is only in California that this applies, then it's very important to do a Prop 65 analysis. That typically requires lab testing, because some of the chemicals on the Prop 65 list are naturally occurring heavy metals, lead, arsenic, things that are really commonly occurring in naturally grown commodities. The safe harbor level, especially for lead, is very, very low, much lower than what our federal government has recognized as a safe level. And the failure to have this warning exposes you and the retailers in California who carry your products to potential lawsuits that get very expensive. So the heavy metals I mentioned, acrylamide is really common in any sort of baked goods or roasted, like nuts, coffee, although now there's an exception for coffee. But if you're selling cookies, you're going to have to get them tested for acrylamide to see if a warning is required. BPA in packaging, those are all common Prop 65 issues for foods. And so it's definitely something, if you're going to be selling in California and there's any chance that you would have Prop 65 chemicals that require a warning, you really need a lab who can do that analysis, come up with a testing program that makes sense for your kinds of products, or just label them. But this is what the label looks like, and it's not something that people want to do from a marketing standpoint.
So
next slide, please.
Sorry.
Yeah.
The label has to look like this because it looks like toxic waste.
Exactly.
Right?
Yeah.
It's a bit scary, no?
Yeah. Although, so I will tell you that it is definitely, it's not attractive, right? You would prefer not to put this on your product, but it is so pervasive in California, and buildings have these warnings on them, right? Because it's so many things fit within this criteria that I think California consumers, I'm not even sure they pay attention to them anymore because they're everywhere. The next slide, please. Okay, so something else that's on US importers' minds these days is the bioengineered foods disclosure, and that's because it goes into effect, meaning products that are entering commerce as of January 1st of next year are required to comply with this law. And so it puts the obligation on the manufacturer, but also on the importer to make sure that a product that requires a label has the label. And a disclosure is required, and this pretty little image here satisfies the disclosure. So a little different than the Prop 65 warning, but even just using this pretty little icon satisfies the disclosure standard. But if a product contains a detectable amount of bioengineered material, then a disclosure is required. Next slide, please. And what's important to know is that a food is going to be presumed to have a detectable amount and to require a disclosure if it is or contains ingredients that are or that are derived from any foods on this list or any crops on this list. So this is a list that USDA has determined are the bioengineered crops that are in the marketplace. It's actually not exhaustive of all of the bioengineered crops that exist in the world, but the ones that it has determined are in the marketplace for the US. And so even if you know that you're not using GMO corn, because where you're sourcing corn from, it's not genetically engineered. The food in the United States that has an ingredient made from corn is going to be presumed to require disclosure unless you have the documentation to show that it's not. So it again just puts importance on record keeping and getting records from suppliers upstream and their suppliers. So next slide, please. So the implications is, again, just expect the importers will need to be verifying compliance, that they'll be asking for documentation and records, and a lot of this information will be proprietary. You may not want to disclose who your suppliers are, but it may be necessary to do so to satisfy these obligations. And so, again, make sure you have strong confidentiality protections in place. And another way to deal with this issue would be non-GMO certification. So the non-GMO project in the United States is maybe the leading certification for food products these days. It's been very fast growing, and that type of certification would satisfy the record keeping obligations to verify that a product does not require a bioengineered foods disclosure. Next slide. That was it. Okay. Are there any?
Yeah, I have a question for you, because we know that the US was very much pro GMOs, and there was a big case on the multilateral level with the WTO, which the US actually won. But what's the shift? What's the reason for the shift and wanting to put labels on? Just the story? I'm curious. How did you shift?
Yeah. Okay, so it's interesting. So the U.S. food industry wanted protection from state laws. So it started with, I think, California, Vermont. Several states started considering, and Vermont actually enacted laws to require disclosure that foods were genetically engineered. And a lot of these laws would have also had similar bounty hunter type provisions or given consumers the right to sue. And the industry, faced with what was going to look like different requirements in different states to require disclosure and different forms of disclosure and inconsistent rules, preferred that there be a federal law and lobbied for it. And so this federal law now preempts any inconsistent state law. So states are no longer allowed to have rules requiring labeling of genetically engineered foods. Only the federal standard exists. It doesn't mean that lawsuits won't be possible. I think they will. I think we're going to see them. If a product does not comply with the federal standard, lawsuits can be brought saying that that is deceptive to consumers. But now there's one uniform standard, and in all honesty, this standard, which, so there was a federal legislation and then there were regulations that came out of USDA during the Trump administration, is I'd say about as industry friendly as you can get, right? So it's not what the consumer groups that were fighting for GMO labeling laws wanted. They certainly didn't want pretty little graphics.
Yeah, the picture says 1,000 words. I mean, it's so green and as opposed to the warning sign. It's like, what? There's something wrong.
Well, you should see. I'll send you what the earlier version looked like, because it had a smiley face on it.
Oh, that's marketing. That's deceptive marketing.
Happy little GMOs. Yeah.
Yeah. Okay. So that makes sense. So a final question, if I may, impose on my colleague. We know that we cannot export meat products to the US because there's no recognition of equivalence. But let's say butter. Can we export butter to the US? And how do we go about that? And could you help one of our companies wanting to export butter to the US? I have number here, I don't know, do you want to maybe better articulate the
Actually,
question?
we know that US is one of the major importer of butter from Europe, and we want to participate in this business. And now from the start, what is required from us to smooth our export to US for the butter? It's
Yeah.
very simple.
So yeah, butter is FDA regulated. Dairy products are FDA regulated, not USDA. So there's not any reason why you couldn't export dairy products. There are rules about particular kinds of cheeses, like unripened or fresh cheeses, but that won't affect butter.
Jordan is on some sort of list that we can't export butter or something. Maybe we can have a discussion about that, because I know the company is keen to see how they can access to understand the system, so they can maybe reach the US market and successfully market their products. So
yeah,
we have a new factory, and we are setting up for the production of butter. Of course, we won't have production of butter, but we will import butter in large quantity and cut it into pieces and then export United States.
Okay. Yeah, it would be helpful to look at the particular circumstances. So, so dairy products are an area where there actually is more state regulation than other kinds of foods. And there's something called the Pasteurized Milk Ordinance, which the federal government puts out as sort of a voluntary, but all of the states adopt it in their own code, and there can be some nuances from place to place. But if you're not familiar with that standard, and your situation is going to be different if you're not actually turning fluid milk into butter, but that's kind of the baseline rules, the Pasteurized Milk Ordinance. So I would look at that. But yeah, I'd be happy to talk to you offline about the particular circumstances.
I mean, we need someone to help us and be our advisor on this issue.
Sure.
Yeah.
It would help to have a food safety person with significant dairy experience too in the United States as a consultant, because a lot of it's going to come down to operational food safety issues.
Okay, thank you.
So I don't know if anybody else has any other question.
Hi, I wanted to ask, is there a requirement or a regulation for that, for example, impose on the food manufacturers to include expiry date, production date, or use date? Because I know for some products in the US we don't have to, right? Like cosmetics, for example, there's no need for to provide expiry date or production date.
So let me just make sure I heard the question correctly. It's a little bit fuzzy on my end. You're asking about product dating labeling?
Yes, for example, expiry or production.
Right. Right. So under US law, the only federal requirements for date labeling are for infant formula. Other than that, there are some states that require best by or pull dates, they're called. And those are really, for the most part, only for very highly perishable products. So dairy products, eggs, and like luncheon meats are the most common ones. But other than a couple states there that have a 9-month, I think is the longest time period for what they consider a food to be perishable, there are no requirements. Now, it is industry practice to use date labeling anyway, and it's often used for traceability purposes, right? So if you have a recall, then that's how you can identify the products that are subject to the recall. And a lot of US buyers won't take your product unless it's got a date label on it. But that's not law, that's just industry practice.
Thank you.
Do we have any other questions among the audience? Okay, Laurie, so thank you so much for entertaining us today and being with us so early in the morning, looking so pretty. And
Thank you.
once again, for this night.
Thank you. Thanks for having me.
And with the end of Laurie's presentation, we would like to thank you all for coming and attending this event. Thank you for Lana. Thank you for all for Hamouli. Thank you for Bank al-Iskan. And of course, Laurie Handel, who I think is not with us anymore. But it has been a pleasure to get to see everybody, to get to have a live event where people can actually interact and have them all in the same room together. So we ran over and above the allocated time for the event, so thank you for bearing with us. But having you with us means it was interesting for you to attend. يعطيكم العافية وشكرا كثير.
Thank you everybody. Thank you for your time. We have with us also Dr. Khalid. I want to take the opportunity to, because he's an SDX expert supporting us. So we have local experts and international experts in the US to help you reach the US market successfully. Along with our banks, we're very privileged to have the Housing Bank. Mr. Khaldoon, thank you. And the amazing, sorry,
and please don't hesitate to reach out to AmCham should you have any further queries. Thank you.